Welcome to the Tailor Law Podcast, where we provide expert insights into family and divorce law in Ontario. I'm Deepa Taylor, and today we're exploring an important and evolving topic in family law, the voice of the child. We'll be discussing how a child's views and preferences are considered in family law proceedings and the legal mechanisms that amplify their voices in Ontario courts. When parents separate, decisions about parenting time, decision-making responsibility, and living arrangements are made with the child's best interests in mind. But how do we ensure that the child's voice is genuinely heard in these decisions? The Voice of the Child report is one way Ontario's family law system allows children's views to be brought forward during legal disputes. But what exactly is this report? Who prepares it, and how much weight does it carry in court? Let's break it down. Under the Children's Law Reform Act and the Divorce Act, courts must consider various factors when determining the best interests of a child. One significant factor is the child's views and preferences, provided they can be ascertained. This principle is also rooted in the United Nations Convention on the Rights of the Child, which Canada ratified, recognizing that children have the right to participate in decisions affecting them. So, what is a Voice of the Child report? It's typically a non-evaluative summary prepared by a professional, often a social worker, psychologist, or trained mental health professional, capturing the child's views and preferences on specific issues in a family dispute. This report gives the court, parents, and lawyers insight into what the child feels and wants without putting the child directly into the conflict. There are two main ways to obtain a Voice of the Child report in Ontario. One is through the Office of the Children's Lawyer, commonly known as the OCL, and the other is through a privately retained professional. The OCL provides legal representation and clinical services for children in family law and child protection cases. When the court deems it appropriate, it can appoint the OCL to prepare a report under Section 112 of the Courts of Justice Act. However, due to limited resources, the OCL cannot accept every case. For more immediate or tailored assessments, parents might choose a privately retained professional to complete the report. This option offers more flexibility but comes with associated costs, typically ranging from $3,000 to $10,000, depending on the complexity of the case and the number of children involved. In some cases, the parents agree to share the cost, while in others, the court may assign payment responsibility proportionally based on income. Now let's discuss how much weight these reports carry in court. While the child's voice is important, it is only one factor the court considers when determining the child's best interests. The court evaluates the child's maturity, consistency in expressing their views, and whether those views may have been influenced by either parent. Ultimately, judges have the discretion to decide how much weight to give to the report. Judicial interviews are another method of understanding a child's perspective, though they are less common due to concerns about placing a child directly in the adversarial process. Courts often prefer the Voice of the Child report, as it offers a more neutral and child-friendly approach to hearing from children. It's important to note that not every case is suitable for a Voice of the Child report. Younger children or those who may be vulnerable to manipulation may not benefit from being drawn into the legal process. In such situations, a more comprehensive parenting assessment or alternative dispute resolution methods may be more appropriate. In cases where a parent disagrees with the findings of a Voice of the Child report, it can be challenged. The professional who prepared the report can be cross-examined in court regarding their methods, potential biases, and conclusions. However, it is essential to remember that challenging these reports requires careful legal strategy, and the court is unlikely to dismiss a report without substantial reasons. The child's right to legal representation is another critical aspect of family law. The Office of the Children's Lawyer can appoint a lawyer to represent the child's interests independently. This legal representation ensures the child's voice is heard fairly and accurately without exposing the child to the stress of direct involvement in litigation. In summary, the voice of the child is an essential component in Ontario family law, reflecting the legal system's commitment to making child-centered decisions. Whether through an OCL report or a privately obtained assessment, the child's perspective can significantly influence parenting arrangements and help resolve disputes in ways that respect the child's needs and wishes. If you're navigating a family law dispute and want to understand how your child's voice can be heard in court, Tailor Law is here to help. Our experienced family law lawyers are dedicated to guiding you through the legal process with care and professionalism. Visit us at tailorlaw.com to schedule a consultation and learn more about how we can support you and your family. Thank you for joining us today on the Tailor Law Podcast. Stay informed, stay empowered, and remember, your family's well-being is our priority. Until next time, take care.